let us move on to our key takeaways section. I'm going to ask each of you what you think the most important things are that practitioners on the webinar today should leave with. So let's go in the order in which you presented. We'll start with Dr. Ignacio Francischelli.
Yeah, thank you very much, David. So, yeah, I wanted to emphasize that sampling has been accepted, but that doesn't mean that it's a done deal. Again, designing a sample properly is a very complicated process. We discussed about that today, and we also discussed cases where even a properly designed sample might not be enough, for example, in the context of class litigation. So specifically to RMBS, definitely we have seen a change in the trend in terms of the court decisions with respect to the use of sampling. Recently we are seeing several trustee cases where the court had found that the use of sample would not be enough to demonstrate where the trustee knew and when about the alleged breaches underlying the loans. And we have also seen recently that the courts are making a lot of emphasis on the specific language in the contracts. So this I think is something that we will start to see as well in the damages model at the class certification stage. Might be harder for the defendants to get certified a methodology which relies on sampling as opposed to re-underwriting the entire population of loans. So yeah, that will be it. David, thank you very much for letting me participate in this webinar.
Thank you, Dr. Francischelli. Greg Mersel.
My big takeaway on this is to think about sampling and statistical analysis generally as soon as you get a class action complaint. And I look at it in two ways. One is how will the other side try to do it and what I need to protect against, and also how I can use it. There might be a situation where I want to do it to reduce cost, or where I feel like there's a way for us to try and promote the points we need. But I think those really help out if you start thinking about it when you get the complaint and consider it along with your affirmative defenses.
Dr. Gary Elliott.
And so I think I'm going to steal Greg's takeaways from his presentation. But I mean, what I would say is that you want to engage a sampling expert, fairly early in the litigation process. You want to make sure that you have a sampling design that addresses the specific question or questions in the case, and think about how things are going to will possibly change during the litigation process. Develop a plan that you think will be adhered to, and have contingencies if not for opt-outs and non-responsive and so forth. Avoid making ad hoc decisions. Decisions are made by different parties in litigation, but you want to avoid ad hoc decisions at various stages of litigation, which generally sort of lead to biases and make your sample no longer representative. As an economist and spending a lot of my career actually in policy, I've been trained to work with bad data. We've all been trained to work with bad data, and there's sometimes ways to characterize non-random sampling to get some kind of meaningful evidence out of the population. But when you start mucking around with stuff, it's very risky, and it's easy to really put holes in punch holes in the representativeness of your sample. Bottom line, start with a solid random sampling scheme, design specific issues in the case, and stick with it.
Dr. Peter Simon.
Thanks, David. My key takeaways are that essentially sampling can be a complicated undertaking. So there are potentially many ways to critique an opposing expert's sample, and even given a valid sample in the class certification context, there are many ways in which an expert can test the results of the sample. Those are my key takeaways.